Hi there. Thank you so much for joining us for today's program, Estate Planning Strategies for Blended Families. I'd like to take a moment to introduce our estate planning attorney at Adair Law, Mr. Josh Boehm. Josh, I'll go ahead and hand it over to you.
Hello, good evening, everyone. Like Gabriella said, thank you for coming and watching a video today. This is our third installment uh, in our estate planning webinar series, and we're talking about estate planning strategies for blended families and the importance of planning for the future in that context. Again, just get this disclaimer out of the way. It's presentations for informational purposes. We are not your lawyers. We're happy to be it, but this presentation does not establish an attorney-client relationship today. So what is a blended family? Modern blended family takes lots of forms and shapes. It results from remarriage, stepchildren, co-parenting, after death of a first partner or spouse. They differ from traditional nuclear families in lots of ways from the eyes of the law and how the various relationships are identified and defined, and how assets and property flow from one generation to the next. Uh, the different families coming together and combining create different emotional and logistical complexities. Uh, and part of this, again, is just by the magnitude and the variety of ways that these families can come together. All families face challenges, and blended families are no different. But they do introduce a few different things to take into consideration. Again, balance of loyalty to a current spouse or partner versus children from prior marriages or relationships. Differing expectations about inheritance, perhaps between current, former partners, biological children, stepchildren, adopted children. Time in the relationship. How long have you been together? How long have you raised the children? Um, did they families blend when the children were all adults? Were they raised from a young age together? What was the involvement of the biological parent? And navigating strange or complex relationships, um, dealing perhaps from a separation or divorce, or the unwanted blending perhaps of a family. Sometimes children from a prior relationship can feel insecure or overlooked. Um, a spouse or partner may have a different expectation regarding financial support. All of these are dynamics to consider and make sure that they do not lead to resentment and that they're managed proactively. And it's not just money, it's love, fairness, and perceived loyalty as well. Some of the ways that these things can be addressed is discussing them openly and making sure that the priorities of the family are established together. So everyone is going to come into this new partnership with different commitments. At the same time, they're trying to establish new bonds. So how can we respect that and make sure that our current and ongoing bonds and relationships are strong? And part of this is keeping the communication ongoing with all the children and making sure that they're involved in an appropriate fashion based on their age and involvement. These things can differ significantly depending on the nature of the assets or the family. Is there a family or closely held business that's being managed that the children from one part of the family are participating in? Or are we trying to bring all the children into that business? What is that going to look like? So communication, like in all aspects of estate planning and really life and relationships, are important. And it's not just at the beginning. Just because you have a plan or have an idea or goals doesn't mean that things don't change over time. And you have to share each other's strategies. Set up a planning retreat, structured discussion, make sure that everyone is in a setting that they're comfortable to share their concerns and visions. We've talked in prior discussions, webinars about fairness. Again, fairness is not always equal. And how you define fairness or how that may look in a blended family is different. Again, you can have age differences, prior support obligations, and you want this to reflect the values that you're instilling in your new family. Again, while making sure that prior obligations are honored. This can look different, again, if you have a closely held business. Have there been individuals involved in that business for a long time? Maybe the individuals involved in the business are no longer part directly of this new blended family, and that they still need to be taken into consideration. Fairness is what you define it as a family, as a partnership. Don't worry about outside opinions, pressure. This is your plan. It should be set up and executed in the way that you desire. There may be a child who has already received college funding or support. They may receive less than a younger child who has not yet received that support. So those are things to take into consideration. That also highlights the importance of continuing to update plans as children age, as you go through different stages and cycles of life, as the needs of the family change. Make sure that you document your intentions and communicate them as appropriate. Making sure that these things are shared as far as expectations, intentions, wishes are with children prior to your death and are communicated, help to reduce conflict and surprise when the written estate plan is revealed. If the plan reflects something that was never discussed or never shared, or maybe is outside of that child's expectation, that can lead to surprise and conflict. We talked about the importance of making a plan because the law is going to define and look at these families differently. And one of those things are to think about who are your beneficiaries and heirs. So your heirs are who is defined at law. Your beneficiaries really are who you define. So biological children and adopted children are heirs. Stepchildren are not and will not inherit as a matter of law without an estate plan that provides for them. Second spouse's children, again, did they remain stepchildren? Were they legally adopted? Are we going to include them or exclude them as part of an estate plan? Maybe there was not a marriage. Is your partner's children going to be included or excluded? And again, the goal is to provide clarity to everyone involved so that we can avoid conflict. Many times people assume that everyone that they consider a family are included. That's not always the case, again, legally. Make sure you consider who you want to include. Define the family in your estate plan, how you define it in your life. Making assumptions as part of your estate plan, like everything in life, can lead to significant problems and significant family rifts. There's lots of different ways this can be accomplished. Use what works best for your family. If you have an established method of communicating or sharing goals and expectations in other parts of your life, utilize that for this planning portion as well. You can do family meetings. It may be necessary to bring in a third party, either at the beginning or at the end. This can be done with attorneys, can be done as part of a family therapy session. There's lots of different ways to talk about what is your family, what does your family mean for you, who do you want to care for, who do you want to provide for, and in what ways. Allows you to explain your decision-making process and concerns. And the different individuals in the family may have ways to address that you had not thought about. They may have additional concerns that you had not considered. Uh, you know, there are often opportunities to have these conversations. You can use a significant birthday or milestone in life to say, "Hey, we need to start thinking about this as we enter, older age, other transitions, perhaps a move, or at the time of the blending, a graduation, um, a marriage of a child, things like that can be used. Significant illnesses, but with someone within your immediate family or someone more extended, the death of a grandparent, a parent, you can use as a trigger to have these conversations. Again, oftentimes a third party, perhaps an attorney, other counselor, can help you begin this discussion. And again, it doesn't necessarily have to be from a planning or gifting or documentation stage. It can also just be from really what is our family? How do we want to preserve our legacy? What are the goals and things that we wish to communicate uh, to that next generation, to our partner, to our spouse? Now we're going to talk through just a real quick kind of example and case study. So we have here the Johnson family. Uh, Dad remarries, has two children from a first marriage. Wife has a child from a previous relationship. So we have a second marriage here in both instances, and we have three children split, but mom and dad do not have children of their own together in this second marriage. The ages of the children could vary and will have to be taken into consideration. For the purposes of this, we're just going to say they're all minors uh, and under the age of 18. They're going to be residing together with mom and dad. So, how do we want to provide for their education? Okay. In this situation, they end up with something that is relatively, I guess, traditional, maybe it would be the correct wording. They do a trust and have equal distributions to the three kids from their marital assets. And then they establish an education fund for the three kids. Again, if one of those children is older and has already been off to college, they may not be provided for. There may be an education fund that's peeled off separately for the two younger children. And it could even be one of dad's, one of mom's. Um, but again, we have to think about how we balance that. As we work on establishing that balance and you identify who your family is and who you want to provide for, things like that, it's important to understand what the default is. Okay. Who inherits if you don't do this plan? And one of the reasons why blended families are especially at risk is because Kansas law does not automatically protect stepchildren. And again, is this a second or subsequent marriage? Is this a partnership where you're living together and there is no legal marriage? Um, the surviving spouse receives half the estate if the children are from a prior marriage, and then the rest is divided among children of the deceased. Okay? Stepchildren are not included unless they've been legally adopted. Okay. Um, so by state law, there are set distributions, and they often contradict a blended family setting and blended families' wishes. But again, these are all things that really depend on how long has the family been together. How long were the children maybe in the new household before they moved into majority? Maybe they never were. They never lived in the new partnership. All things to take into consideration. And again, this is why a personal plan is particularly important, because intestacy laws, the default distribution plans have been around for, you know, about 100 years, really with minimal changes. And that really is across all states. These are set up with very traditional family unit, single marriage, one marriage, families into consideration, very dependent on blood and biological uh, transition of property. So that's how this is going to fall and follow outside of a plan that records your wishes. As you work on setting your priorities together, you're going to look at different tools. Okay. Last will and testament is going to be part of every plan, like we've discussed before. Uh, it may just be a pour over will that moves everything to a trust. It could be the only estate planning tool that you have, and your distribution will be handled through that last will and testament. Oftentimes, again, when there's minor children involved, we will create a testamentary trust, perhaps for some life insurance proceeds or something like that to be held for a minor. Once all the children have reached the age of majority, the need for those tools goes away, and we can operate just with that pour over will and a trust. Trusts are particularly useful in a blended family setting because it allows us to divide assets into different pots and pools easily, to where pot A can be managed for the benefit of these children, pot B for these, pot C perhaps for a partner or spouse. It can be divided up into lots of different ways. There could also be a pot that is managed for all of the children, both partners jointly. So there's lots of different ways that we can manage those funds. Um, the different pots don't necessarily need to be in different accounts or under different people's management, although they could be. You could have one individual managing the trusts for the children of one spouse or partner, and then another individual managing for other children. So there's a lot more discretion and options available under the trust. And the trust, again, is not going to be subject to continued court oversight, reporting, and public disclosure. Power of attorney and healthcare directives become particularly important in a blended family setting. Who is going to, again, have those healthcare decisions regarding a parent? You know, oftentimes this can lead to conflict where a child feels like they should be making those healthcare decisions on behalf of their parent, not the new partner or spouse. So laying out who is going to have that decision making authority. And again, these are things that can change over time. And this is, again, reiterates and stresses the importance of continuing to update your estate plan as your life and the seasons change. So maybe initially it is an adult child who you want to be making those healthcare decisions, but maybe 5, 10, 20 years at some point down the road, you want that to transition to the new partner or spouse to make those decisions. Powers of attorney are also important because there's going to be elections in there, or you have the ability at least to make the elections related to disposition of your body. So again, making sure that children are looked after and provided for, or a new partner or spouse is, who is going to get to make the decision relating to where you're buried. Are you buried? Are you cremated? Do your ashes remain together? Are they cast? Do different members of the family each receive a portion of those? All of those different things are issues that can be addressed in a power of attorney. and can often lead to significant conflict. And again, that's something that's going to change and probably pivot over time, depending on the age of perhaps children, the length of the relationship, things like that. Uh, it's important to work with a trusted advisor, an attorney on these documents to help you think of and work through all of the different parts and pieces that can come up, the different challenges and issues that can be raised. We write these plans every day. We probate estates on a regular basis and handle lots of estates with conflicts. So we know some of the questions and things like that that come up, uh, all the different things that can be challenged and fought over, and being able to work through those, plan for them, and address them on the front end really helps to uh, prevent conflict amongst the family. They're able to see what your wishes were uh, and see them reduced in writing. They may still not agree to them, but having it written down, having a plan that's been executed and been kept up to date is important. So oftentimes a written plan, um, again, if it's not maintained, can also lead to conflict and issues. So I don't think that just because you did it today, again, 30 years from now, um, expectations aren't going to have changed, or people aren't going to be thinking, oh, this needed to be updated. So, and again, estate planning documents are not just for after your death. They can be great tools in the event of an incapacitation after an accident, serious illness, or something like that. The more complete and detailed your documentation is, the less stress, delays, and court involvement there will be for your survivors and family members. It really is a great last kind of gift to give to them. Customizing documents, not just wills, again, allow you to designate specific bequests. So maybe an item to go to a particular family member. It prevents accidental disinheritance. Again, we talked about how stepchildren are not necessarily provided for it by law, and allows you to choose who you trust to carry out your plan and wishes. Again, there's lots of different options in a trust, including multiple different types of trust. Again, revocable living trusts are generally the most common tool, and they provide great flexibility. But there's all sorts of other revocable and irrevocable trusts. Uh, Q-tip trust can provide for a spouse. You can create lifetime trusts for minors or dependent children. There's life insurance trusts. Uh, Again, there's any number of forms and purposes to those to meet your needs. So trust can help a new partner or spouse feel secure while ensuring that there's an inheritance available for your biological children. Um, Oftentimes, we'll see a scenario where everything is left to the surviving partner or spouse. Uh, that partner or spouse then goes on and remarries, or writes your children out of the plan and transfers everything um, to their children. Again, part of this planning is if there's minor children, okay, a step parent um, may not automatically become the guardian, okay. Um, Typically, it's going to be the natural parent or guardian if they are still living. Uh, if they are not, again, it's not always going to be the step parent or the new partner. So make sure if that's what you want, that that's established and that's set up through your planning documents. You can also look at adoptions, step parent adoptions, and things like that. Okay. Again, real property and home ownership. What happens for the family home? There are ways for co-ownership of a property, providing for survivorship. Transfer on death deeds are a tool. Um, Transactions done in deeds, again, are revocable, can be changed at any point prior to your death, as long as you still have capacity. Okay. But making sure, you know, if a house was owned or property was owned by one individual prior to the blending of the families, again, particularly the longer the relationship lasts, the more important it becomes. Um, but there could be a situation where it passes to an heir or a beneficiary and leaves the new spouse or partner without a residence. Okay. But again, a lot of that depends on the length of the relationship and how you're going to set that up. We talked about specific bequests. Again, that comes particularly important in blended families when you're dealing with family heirlooms. If you have antiques or personal items that you are wanting to keep within a family, these specific bequests can be written into the base documents, into the main type documents, or Kansas law does allow for a personal property memorandum. It's kind of a little attachment that you can put with a will or a trust, and you can update it at different points in time. It's only binding for like personal property. It doesn't work for real property, and really only applies to sentimental items, photo albums, maybe grandma's pearl necklace, silver from somewhere, things like that. So make sure those can be designated, and they don't have to be to an individual who is named at any other place in the will or trust. It could go to a cousin, sibling, neighbor, um, charity, whomever. Clarity of all the documents. Sometimes, most importantly, to those written memorandum. Um, Oftentimes, we'll see maybe a memorandum that says my gold ring. And if there's 4 gold rings, conflict is sure to ensue. Uh, my 12 gauge shotgun, and there's 3 of them. Which one are we referring to? So provide written explanations when needing, make sure that the decisions are clearly communicated. And sometimes we'll even put in there little hints at what the rationale is. We typically don't detail it too much, in part because that significantly changes over time. But oftentimes we'll provide little hints in the documents. Again, if there are stepchildren who have not been adopted, it's very important to make sure that they are deliberately included or conversely excluded as part of making sure things are clearly communicated. And as part of that, we want to balance the obligations across the different family sectors. Long-term care also applies to blended families. Okay. Medicaid planning, support for dependent children or adults, including perhaps those with special needs. And again, we want to make sure that we are not bringing in or involving perhaps a side of the family that we didn't need to, or maybe burdening one side more than the other. Again, all of these things that we talk about when it comes to blended family, a significant part of it depends on the length of what that relationship is. Oftentimes, the new blended family is a family unit that is in place and longer than the first family, perhaps where children came from. Oftentimes, it's not. It doesn't come together until after children are grown and out of the house. Um, there could be 2 or 3 blended families in a person's lifetime, depending on how relationships last, deaths, etc. And again, a big part of this is to make sure, like any estate plan, that your legacy and your values are clearly communicated to that next generation. How do we incorporate that? Um, what do we want to teach family and children about savings, about management, again, business, the importance of charitable giving? How do we incorporate, when you have two different or maybe three different families coming together and blending, how do we make sure that all of the various traditions and values are honored and recognized and communicated to everyone clearly, particularly when there's going to be individuals in the family who are familiar with one part but not necessarily another, and making sure that all uh, goes together. So oftentimes we create opportunities that force children or families to work together after death, maybe between a joint vacation fund or planned family giving project. There's different things that you can do to, again, continue to encourage the family members to stay together when that linchpin is gone. Okay. Another quick case study. Again, you don't update beneficiary forms. Okay. So we talked about what happens in the event of not doing a will or a trust or having those estate plans in place. But don't forget about your beneficiary forms on retirement accounts, life insurance policies, bank accounts, transfer and death on vehicles, perhaps. Okay. Those are easy documents to forget to update. They're going to be done separately outside of perhaps divorce or prior death or inheritance. Uh, and we can, again, unintentionally exclude stepchildren. We can unintentionally exclude children uh, of that second relation or third relationship by not updating those forms and only leaving on, whoever was around at the time that that policy was taken out, that retirement account was started, often years and years ago. So just like we have to update our estate planning, part of that estate planning is making sure that these beneficiary forms and designations, whether it's in a retirement account, life insurance policy, bank account, wherever it may be, an annuity, that those are updated. As you get older, as you experience illness, as the families change, those reviews should be completed. And the later in life you get and the value of those accounts and the value of those assets change, you may need to go to annual reviews of those. Make that part of your annual family planning. And everyone needs to be on the same page. Um, Again, this is a family, blended, traditional, whatever it is, it's a family. And everyone needs to be on the same page. Find a way to build a consensus to get along, reduce and avoid conflict. Attorneys can help facilitate family discussions because, again, we execute these plans not only from a drafting stage, but from administration on the back end, conflict regarding them. Uh, we do this on a daily basis. You're going to do your plan, and your plan is really your only concern. Uh, but we've seen hundreds, if not thousands, of families go through this and can build on that collective experience and give you examples of maybe what someone else has tried, options, what has worked, what hasn't worked, what maybe the average situation is. But we can pool, again, that collective knowledge and experience to provide some options and insights for you. When you work with a partner or a third party to start working on this and go through this, you should look for someone who can provide you questionnaires and inventory forms, conversation guides, again, little things that can get you started on this. Okay. So oftentimes people don't have conversations because they don't know uh, where they need to start or what they need to cover. Again, reach out. We can do this in stages. Okay. Ways to get started, things to consider, and then you can go back and have those conversations as a family, as a couple, with your partner, your spouse, to figure out how do we want to accomplish all of these different objectives. What's the best way for our family? What is our family? Are there any questions?
Hey, Josh, yes, I had a question that I wanted to present to you.
Mhm.
Um, in a situation where I'm wanting to set up my estate planning and I am remarried and my spouse is either about to have a kid or we have a new kid, is it best to have that conversation first one-on-one with you? And then bringing the spouse in, or should it be something that I'm doing with them at the same time? How do you, what do you recommend on something like that?
Yeah. So we can do it either way. It really depends again on what your goals or your concerns are, what conversations you've had with your partner or spouse leading up to it. So and some of it will depend a little bit on are you married or are you not. Um, there's different rights again legally that attach with marriage that don't outside of that, and there's ways to create those even within a marriage. There's ways to kind of dissolve some of those rights to provide flexibility and things like that. Um, if you are unsure of where to start that conversation, or maybe you've tried to have that conversation with a spouse or partner and it hasn't gone well, definitely feel free to come in and speak with someone first. Again, we can answer what some of your greater questions or concerns are. And maybe if there's some roadblocks or hurdles that that partner or spouse is throwing up as to why not to do this, we can give you some ideas or talking points to that you can use in trying to address those concerns. And if the spouse or partner does not want to engage in the process, again, depending on what the family situation is, we can still do planning for you on an individual basis. Um, our options may be a little bit more limited than doing it together as a family, but it's definitely something that we can do. Um, you know, single, married, not married, first marriage, fourth marriage, um, no matter the situation, we can still do it on an individual basis.
Thank you. Another question that came up is what kind of documents would you need to see in order to get started on something like this? Or do you need any documents to start?
We really don't need any documents to start. If you are really just kind of looking to get going and maybe don't know how to have the conversation or what needs to be considered, typically we will typically if you reach out to us, we will provide you with a intake packet so that we have a better idea of what your family looks like, what you have that as far as at least assets that need to be addressed and provided for amongst the various family members for distribution. Uh, and we can provide you a page, I think it's about a page of kind of, again, questions or things to consider, as far as what are your priorities? What are you trying to maximize or accomplish with this goal? If you check the box for all 20 things, we're not going to be able to accomplish everything. Every plan has balances and give and takes to them. But again, it gives you an opportunity to start thinking about what the talking points are, what your objectives are. But if that's too much or too overwhelming, then we can walk through it from a little earlier in the process and again, break this up over multiple meetings. On the flip side, if you really know what you want, you've had deep discussions with your partner or spouse and have worked through and have thought about this, you know, then we can complete this, in fairly short order.
Wonderful. Thank you so much. Is there any other questions from attendees that I have missed? Well, if not, thank you all so much for attending today's webinar on estate planning strategies for blended families. As Josh indicated, he is always here to help support clients in determining what it is that they want to accomplish, how they can accomplish it, and even giving you guidance for how to have those tough conversations. The reality of estate planning is that it should help you open up and have tough conversations so that when something happens to you, your family continues to be a strong family unit. And I know that's what Josh wants to help accomplish. Thank you all so much, and tune in next time. In August, we're going to be hosting our next webinar, which is about, and I'm so sorry I don't have it up, but Josh, do you happen to have the webinar pulled up?
I don't have August. I know we have October is the other one, and that's going to be after death.
Correct. The August 19th is future proofing your assets estate planning for millennials and Gen Z. And so if you know of any millennials or Gen Z individuals who are starting to contemplate how they must protect their assets, please encourage them to attend this webinar. This will be a great one for them. Thank you all once again. We appreciate your time, and we hope this has been informative for you. Goodbye.